That's cool.
Hello everyone, today Matisse and I will discuss crime and justice in Japan. I will start by introducing criminal groups focusing on the Tokuryu and Yakuza organizations, and I will address the legal challenges surrounding them. Matisse will then focus on the criminal justice system and its responses to these issues. So first, let's talk about Tokuryu groups. These organizations represent a significant departure from traditional Yakuza. The term Tokuryu comes from the characters for anonymous Tokume and fluid Ryodo, reflecting their decentralized, loosely connections. Unlike the highly hierarchical Yakuza, Tokuryu groups often lack clear leaderships and operate through flexible networks where members may not even know each other. This anonymity makes them particularly difficult to dismantle. In 2024, over 10,000 people were arrested for crimes reported to linked to Tokuryu groups, and with more than 3,900 of them recruited through shady part-time jobs or Yamibaito, often advertised on platforms like Instagram. This modern tech-driven approach sets them apart from the more traditional Yakuza. Next, while the Yakuza have seen a decline in numbers, they have not disappeared. In fact, some Yakuza organizations have found ways to indirectly profit from Tokuryu operations, integrating these anonymous groups to their broader criminal networks. However, unlike Tokuryu, the Yakuza still maintain a strong presence in Japan and often operating through front companies to hide their activities. This evolution reflects a critical difference between those two types of organized crimes as the Yakuza adapt to survive in a society increasingly hostile to their traditional structures. And finally, the challenge for Japanese law enforcement is also significant. Unlike the United States, which has the racketeer influenced and corrupt organizations RICO Act, Japan lacks a similar legal framework for targeting the leadership of organized crime. Instead, authorities rely on a patchwork of laws like the Organized Crime Countermeasures Act, revised in 2008. However, these measures have their limitations, often ending in private settlements rather than substantial convictions. And in conclusion, while Tokuryu groups represent a more fragmented, less visible form of organized crime, the Yakuza still remain deeply embedded in Japanese society, adapting to changing laws and economic pressures. Understanding these evolving dynamics is quite essential for addressing both traditional and emerging criminal networks in Japan.
Now let's talk about the criminal justice system in Japan. Japan has a legal system widely regarded internationally as competent and impartial, but its criminal justice system functions on laws and procedures that systematically violate the rights of the accused person. The problems are so deep and so ingrained that it is known as the hostage justice system. This is a misunderstood aspect of Japan that has recent implications. The problems are so widely known that the Japanese language has a word, henzai, for false accusations that lead to a person becoming a victim of the justice system. On September 26th of 2024, in a ritual, Iwao Akamada was acquitted. He was sentenced to death for murder in 1968, but the presiding judge found that the investigating authorities had fabricated evidence in his original trial. Prior to his interim release in 2014, the 88-year-old had spent over 45 years on death row, much of it in solitary confinement. This law case questioned the Japanese judicial system, underlining violations of human rights. First, we can talk about bail denials and multiple arrests. Indeed, the Japanese Code of Criminal Procedures allows suspects to be detained up to 23 days before indictment, with a first period of 72 hours and two extensions of 10 days. Prosecutors repeatedly make new arrests and on new charges to induce confessions. After each new arrest, the pre-trial detention period restarts. This system is contrary to international standards and especially Article 9.3 of the International Covenant on Civil and Political Rights, to which Japan is a party. In Japan, there is also a weak right to counsel. Police and prosecutor easily obtain lengthy detentions of criminal suspects prior to filing formal charges, during which time attorneys are prohibited from attending interrogations of their clients. But most suspects confess during those interrogations, so that is a problem. And there is also abusive interrogations to obtain confessions, whereas the Japanese constitution is absolutely clear about it. Investigating officers have used intimidation, threats, verbal abuse, and sleep deprivation to compel suspects to confess or provide information. Koji Fujimoto states that there is an overemphasis on confession in the law of evidence, and that torture, in a sense, has not yet been abolished in Japan. You can put on pause to read some eloquent testimonies, but there is also other human rights abuses. For example, the prohibition on communications with family and others because of the contact prohibition order that can issued very routinely and that restrict detainees to meeting and communicating only with their lawyers. There is also a severe lack of healthcare in Japanese penal detention facilities. And in Japan, the prosecutors has a lot of power. There is a 99.8% conviction rate in cases that go to trial, so the decision to indict or not has enormous significance. Professor Kana Sasakura claims that trials are often reduced to ceremonies for ratifying prosecutor decisions. Here is our bibliography, and thank you for your attention.